Good morning and welcome to the Supreme Court of the United Kingdom, where today and tomorrow we are hearing the appeal in Evergreen Marine UK Limited and Nautical Challenge Limited. I'm Lord Lloyd Jones and I'm sitting with my colleagues Lord Briggs, Lady Arden, Lord Hamblin and Lord Burrows. In addition, we are sitting with two nautical assessors, Captain Nigel Palmer, OBE, MNM, and Commander Nigel Hare, RN. They are both very welcome. Their function is to advise the court upon questions of navigation and seamanship, matters on which they're expert, should such questions arise. However, the decision of the case rests entirely with the justices. In the event that we wish to seek the advice of the assessors on matters within their experience, we will first hear counsel on the appropriate question or questions, and we will also afford an opportunity to counsel to make submissions on the advice that the assessors give. The appellants, Evergreen Marine UK Limited, are represented by Simon Rainey, Queen's Counsel, and Nigel Jacobs, Queen's Counsel. The respondents, Nautical Challenge Limited, are represented by Vasanthi Selvaratnam, Queen's Counsel, and James Shirley. The case is being heard remotely by WebEx because of the current pandemic. The hearing is also being live streamed on the court website. The appeal concerns a collision between the large container vessel, the Eversmart, and the very large crude carrier, Alexandra I, which occurred within the pilot boarding area just outside the dredged entrance-exit channel to the port of Jebel Ali in the United Arab Emirates on the 11th of February 2015. Further details of the appeal are available on the Supreme Court website. Rainey.
May it please the Court. This is the first collision appeal in this court since the decision of the House of Lords in 1976 in the Savina, a case also by chance, in part concerning the crossing rules, and for that reason in the Court's authorities bundle. Both issues before the Court, issues 1 and 2, are issues as to the construction and the application of the crossing rules in the collision regulations, rules which are of cardinal importance in navigation as they address the common situation of crossing vessels, a situation which is highly productive in busy waterways, of close quarter situations and the risk of collision. And for that reason, as the cases stress, the crossing rules are to be applied wherever possible to crossing situations as they arise and as they are defined in the rules and are not easily to be disapplied. Lord Wright's dictum in the Alcoa Rambler and Mr. Justice Sheen's dictum in the Maloja 2 are just examples of the stress placed in the cases. The instrument which the Court is construing, the 1972 collision regulations, while a creature of international convention, is different in nature from many other such instruments. It is not concerned with legal rights and responsibilities, such as the Hague-Bisbee Rules, for example, or the Warsaw Convention. Instead, it is setting out a practical text for seamen and mariners designed to give clear and authoritative, straightforward guidance as to how vessels of every kind are to be navigated, what used to be called, and still sometimes are referred to, as the rules of the road. It is a set of practical rules which have to apply to different vessels, different mariners of many different types and skill sets and attributes, in many different situations, and to do so internationally. And for that reason, the text is sparse and succinct. The parties are agreed as to the principles, long settled on the cases, as to the construction of the rules given these particular circumstances. Literal as much as possible, to make things clear for mariners, to be capable of easy application and understanding, and to promote safety and to avoid the risk of collisions and close quarter situations. The appellant's case before this court on both issues is that the courts below went wrong in law and have added glosses to the crossing rules, which firstly, the text of the rules does not support. Secondly, which is inconsistent with the working of the rules, or based on a misunderstanding of how the rules work and should work. And thirdly, is contrary to settled authority and, equally importantly, long settled commentary, legal and practical. Commentary in this context, in the context of the collision regulations, is perhaps of more importance than in others. For books such as Cockcroft and Lemire, for example, the book by Captain Cockcroft and Captain Lemire, both collision gurus, if I can call them that, very involved in the rules and the drafting of the rules. Their practical guide to the rules of the road, a stalwart since 1965, are not just on Admiralty lawyers' shelves, but on the bridge of cargo ships and other large ships, as well as on yachts and pleasure boats. And they reflect what has long been understood to be the position and the common sense view, supported by examples from the cases. Against that general background, I therefore turn to issue 1. And issue 1 raises the broad question for this court: in what circumstances will the crossing rules be applicable to navigation involving a narrow channel, which is subject to its own narrow channel rule? And I propose to address issue 1 in 4 sections. First of all, I will consider with the court the relevant rules, rules 2, 15 to 17 and 9, and their language. Then I will consider, secondly, relevant authority, which has already considered the application or non-application of the crossing rules in conjunction with the narrow channel rule, and what we say are the principles to be derived from those cases. Third, I will consider the navigation of the Alexandra 1 and how that is to be classified in the light of that authority. And then lastly, I will consider the reasoning of the courts below and make our submissions as to why this court should hold that they were wrong. So if we start with the rules themselves, I don't know where the court has the rules. They are in various places. They are, for example, summarised in the judgment of the Court of Appeal. They're also in the appendix, the Respondent's case. And if the court wants the full text, they are in the second volume of authorities. Would the court like me to give a reference, or does the court have the rules to hand?
We have them to hand. Thank you, Mr. Rainey.
Thank you. So issue 1 concerns the construction and application of effectively 4 collision regulation rules. Firstly, Rule 2, which is the split into 2 parts, and which consists firstly in Rule 2A of the underlying general duty of good seamanship, which applies in all situations. Secondly, Rule 2B, which is referred to in some of the older cases as the general prudential rule, which is that in extremis, in difficult situations and emergencies, the rules can be departed from. So in our submission, Rule 2 stands effectively as a background or backdrop to the other rules which the court has to consider. Next, we have Rules 15, 16 and 17, the crossing rules. These are contained in Part B, Section 2 of the collision regulations, which set out all of the steering and sailing rules which apply when vessels are in visual sight of each other. And the court will have read these, but if I just take the court to Rule 15, Rule 15, which we'll have to consider in both contexts of Issue 1 and Issue 2, applies to all crossing situations as are defined by the rule. And the requirements under Rule 15 are capable of ready and robust application, and the rule applies in 2 situations, or 2 criteria are required. 1, the vessels must be crossing, so the paths being followed by one vessel will cross the path of another. And second, that crossing must be such as to involve the risk of collision, as defined, but also dealt with in Rule 7, because it will bring the 2 vessels together or will lead to a close quarter situation. And as I've already touched on, because crossing situations are legion, and because they are one of the commonest causes of collision, the crossing rules are given wide and strict application wherever they can be, the Alcoa Rambler and the Maloja too. Rule 15, when it applies, once it is engaged, then imposes different rules on each vessel involved in the crossing situation, depending on their position relative to each other. So the vessel which has the other approaching on her starboard side is the give-way vessel, and under Rule 16 is required to take whatever early action is necessary to keep out of the way. The vessel which is approaching her on her starboard side, and therefore which has the other on her port side as she approaches, is the stand-on vessel. And under Rule 17, she is to keep her course and speed. And one of the questions for this court is how those rules, 15, 16 and 17, will apply where there is a crossing situation. I'll come to that in just a moment. The next relevant rule is Rule 9, which is the narrow channel, which is also in Part B, Section 2. And Rule 9 subject matter is specifically confined to and concerned with special rules which apply to, in certain defined circumstances within a narrow channel. And in our submission, it's important to note at the outset the language of Rule 9, and in particular Rule 9a. Rule 9a applies, and applies only on the text of the rule, to a vessel proceeding along the course of a narrow channel. And we emphasise the words proceeding along the course of a narrow channel because they're going to come up in the cases we're going to be looking at. So Rule 9a on the application of the language of the rules has no application to vessels which are not proceeding along the course of a narrow channel. So prima facie, and before one comes to authority, Rule 9a would have no application to a vessel such as the Alexandra I, which is outside and not inside the channel, which is not navigating in the channel, and which is not navigating along the course of a narrow channel. But those words are important in seeing in what circumstances and the cases Rule 9 has been applied outside the confines of the narrow channel to what vessels doing what. The other rules in Rule 9, Rules 9b to 9f, are other narrow channel rules, and we asked the court to note Rule 9d, which is a rule which prevents or prohibits vessels from impeding the channel user when they want to cross the channel. But the importance of Rule 9d is one, a restriction on how you cross and when you cross, but is that it reflects that crossing situations in a narrow channel will arise and therefore must be catered for. So if we pause and looking at the text of the rules and take Rules 15 and 9 together, and I want to posit two simple situations. Situation 1 is vessel A is in the narrow channel and is proceeding along the course of the narrow channel. Vessel B is in the channel also, but is proceeding on a course right across the channel. She wants to get from one side to the other. Take, for example, a mooring on one side of the channel and she needs to go to a wharf or jetty on the other side. So she's on a course, vessel B, which crosses the T of the channel. That's situation 1. Take a slightly different situation, which analytically is no different in our submission. Vessel A, as before, is in the narrow channel and proceeding along its course. But it is now proceeding towards the exit, or the mouth of the channel, so as to leave the channel. But at the moment, she's still within it. Vessel B is not in the channel, is outside the channel, and is proceeding on a course right across the exit, or the mouth of the channel. She's not intending to enter or use the channel, she's simply passing through the waters in which the channel ends. And again, she's on a course which crosses the T of the channel. In those circumstances, in both situation 1 and situation 2, there is a crossing situation where there is a risk of collision, and which falls directly within Rule 15. And if we consider our channel, the channel which the court is considering in this case, with one side bounded by the west, the other side bounded by the east, and ask ourselves how those two sets of rules, Rule 15 and Rule 9a, apply, they apply as follows without any inconsistency or difficulty. In the west to east situation, vessel B, which is inside or outside the channel, and which is going straight across the channel, or straight across the channel mouth, has a crossing vessel approaching on her starboard side. That is vessel A, coming up. Vessel B gives way to it under Rule 15 and Rule 16. Vessel A, which is inside the channel, and proceeding along the course of the channel, must keep to the starboard side of the channel, Rule 9a, and must maintain her course and speed as the stand-on vessel, Rule 15 and Rule 17a1. And there is no difficulty in applying both rules, as we'll see in the cases, in that situation. And one of the aspects the court will have to consider is the spectre raised by the Court of Appeal of conflicting requirements which place mariners in invidious situations. There aren't any, and they don't place mariner in that simple situation in an invidious position. Contrast the east to west situation. Vessel A, within the channel, proceeding along its course, coming towards the exit, now has a crossing vessel, vessel B, on her starboard side. Whether B is proceeding across the channel inside it or is across the mouth outside it. Vessel A must still comply with Rule 9A and keep to her starboard side of the channel, but she must now give way and keep clear of Vessel B, which has the right of way ahead of her. Rule 15 and Rule 16. Most commonly, she will slow down. Vessel B outside the channel is the stand-on vessel and must keep her course and speed across the channel, whether inside it or outside the mouth, so that Vessel A can judge how to keep out of the way, Rule 15 and Rule 17A1. And in our submission, there is no inconsistency between the two rules, and they can be and are applied together. And we will see that in the cases. In Lord Wright's words in the Alcoa Rambler, wherever possible, the crossing rule should be applied to a crossing situation and strictly enforced, because they promote safe navigation. And in those two situations, they do. Why? Because they set out a clear and definite system of priority in a crossing situation involving a narrow channel. Who gives way to whom in a situation where one vessel is proceeding along it, the other vessel is not, but is crossing it. And that rule of priority is needed just as much and applies just as much in the two examples of Vessel B, a vessel which is not proceeding along the course of the channel, but is simply crossing across it, whether herself inside the channel or proceeding outside it, but across the channel mouth. So those are the rules, and those are how they fit together in a simple crossing situation, which I've defined, situation 1 or situation 2, inside or outside. The second section then is to consider the authority on Rule 15 and Rule 9, where the courts have already considered how those two rules are to fit together. And our overarching submission is that it is long settled by authority that in certain well-defined circumstances, Rule 9 will displace Rule 15 or render Rule 15 inapplicable. But that it is equally well settled by authority that in certain circumstances, Rule 15 will apply to a narrow channel situation in tandem with, i.e. in conjunction with, Rule 9. They both apply. Therefore, relegating the view that they are inconsistent and pose conflicting requirements as flawed. And we submit that the cases establish 6 propositions. And so what I want to do is to outline what those propositions are and then make them good. The propositions effectively summarise what we've set out in paragraphs 27 to 56 of the appellant's case. Proposition 1, and if the court would find it helpful for these to be typed up and supplied to the court, I can ask for that to be done. I should have thought of it, but I think in a virtual hearing, rather than hand things out, it's presented too many technical difficulties.
That's helpful for Mr. Rainey, thank you.
We will do it, my lord. Proposition 1, the crossing rules are inapplicable in the situation of 2 vessels in a narrow channel, one proceeding in one direction along it, the other proceeding along it in the other direction, even where their courses are crossing. That is what we described in our case as situation 1. Secondly, my lord, Lord Briggs.
And Mr. Rainey, I assume they may be crossing because it's a curve. They may appear to be crossing because it's a curve. Although if maintaining their course means going along the curve, that may be more apparent than a real crossing.
My lord, that is just the example which is given in the cases of where a crossing situation may occur. A curving channel or a channel with different aspects from time to time. And so if you see the vessel ahead of you, downreach or upreach, she looks as though she's crossing. But by the time you get there, she won't, because you're going port to port, if you both keep starboard.
Yeah.
So that was proposition 1. Proposition 2, the crossing rules will nevertheless apply fully within a narrow channel where vessels are, or a vessel is, navigating otherwise than proceeding along the course of the channel, for example, by crossing across the channel, or joining a channel at a junction with the channel. And that is what we've described in our appellant's case as situation 2. Third, and this will possibly be the proposition where we need to spend the longest time, by limited extension, where one vessel is proceeding in the narrow channel to the channel exit, and another vessel is entering the channel, or is on her inbound entry approach to the channel, but still outside the channel, the crossing rules will not apply by analogy with the both vessels in the channel situation. And for shorthand, that is what we say Lord Clark was referring to in Coulimesin in Hong Kong as the continuity principle, which is applicable at the entrance to the channel to vessels entering the channel. Proposition 4, in all other cases, the crossing rules will apply where one vessel is proceeding within the channel and the other vessel is navigating outside the channel and across the channel mouth, but is not yet entering the channel. What we described in our case as situation 3. So that's effectively my situation 2, which I outlined when I was looking at the 2 rules and looking at vessel A and vessel B in my 2 examples. Fifth, no authority suggests, still less supports, the non-application of the crossing rules where one vessel is proceeding within the narrow channel to exit it and another vessel is not entering the channel but is navigating or manoeuvring outside the channel and across it, preparatory to entering it. And the cases of the Canberra Star and Coulimesin, which you will have seen the trial judge, the Admiralty judge, and the Court of Appeal relied upon, we say do not support that proposition and are straightforward applications of the settled continuity principle, my proposition 3. And last and sixth, for good measure, it makes no difference whatsoever to the foregoing propositions that the mouth or exit or entrance of the channel lies in an area designated as the pilot boarding area for channel transit or for any other type of transit. And that addresses the factor brought in by the Court of Appeal but not brought in by the Admiralty judge on issue 1, that it makes a difference that this channel debouches in a pilot boarding area. It makes no difference in our submission on the authorities. So those are the 6 propositions, and I will hand those now to Mr. Jacobs so that he may type those up and so that I can provide them to the court as soon as possible.
Thank you.
Proposition 1, let me consider the cases on proposition 1. Crossing rules inapplicable to 2 vessels proceeding in different directions along the narrow channel. And the locus classicus here is the dictum of Mr. Justice Wilmer, as he then was, in the Empire Brent. So if I can take the court to that. Is the court content for me to give just a page reference in the electronic bundle, or does it have the hard copy authority bundles?
No, we don't have the hard copies of the authorities, but if you could just give us the electronic number, that'd be really helpful.
Right. So if we go to the electronic number, just say, when I give the number, CV 369. A decision of Mr. Justice Wilmer in 1948, and the facts can be very easily taken from the short form head note 369. Collision river narrow channel rule. This is yet another Mersey collision. They used to be very, very prevalent. A narrow channel rule, crossing rule, collision between steamship Stormont and Empire Brent in River Mersey. Stormont bound up, Empire Brent bound down. So those are the facts, classic up-down collision in a narrow channel. And if I can ask the court, please, to turn to page 375, and the obiter dictum of Mr. Justice Wilmer, certainly, but considered as authoritative in later cases, as we will see. And if I can take the court to column 1, I can explain why it was arbiter. The judge had found vessels were green to green, so there was a situation which would fall within the rules. In the middle of the third paragraph, there's a starting alternatively. Alternatively, it is said that if the vessels were green to red, then the crossing rule would apply, and the Empire Brent, being the stand-on vessel under the crossing rule, ought to have kept her course and speed and ought to have refrained from starboarding. That alternative way of the case has become academic, and I skip to the next sentence, but lest it should be thought that I agree with it, I should like to take the opportunity of saying that I regard that contention as wholly wrong. As I understand the principles which apply in narrow channels, it has been laid down for many, many years, and so he's summarising effectively a large body of authority which we no longer need to go to. It's been laid down for many, many years that although the crossing rule does from time to time, and then I ask these words to be noted, have to be applied in narrow channels. So although the crossing rule does from time to time have to be applied in narrow channels, and then he gives an example. When, for instance, a vessel which is crossing the channel has to act in relation to a vessel which is proceeding up or down the channel. So that's my example this morning of vessel A and vessel B, situation 1. Simple crossing, going from one side to the other, and vessel using the channel going up or going down. Nevertheless, when vessels are approaching each other, so that's important, navigating respectively up and down, so those are taking two vessels both proceeding along the course of the narrow channel, it is Article 25 of the collision regulations which applies and applies exclusively. There's no room in such a situation for applying the provisions of the crossing rule at the same time as the provisions of the narrow channel rule, because the requirements under the rules are different. I have no hesitation in saying that as between a vessel coming up and a vessel going down, approaching each other in that way, in a narrow channel, those words are also important, like the Mersey, the narrow channel rule and the narrow channel rule only is the rule which has to be applied. And the reason why Mr. Justice Wilmer is saying that leave aside a crossing situation when the vessels are going up and going down, proceeding along the course of the channel, the requirements under the rules are different and you don't need the crossing rules, is because the rule of priority is that both vessels keep to the starboard side of their channel, their starboard side. And therefore, sorry, my lady.
I wanted you to complete the proposition, but then I wanted to ask you a question, please.
Yes, of course. The position applies when vessels are proceeding along the course of the channel, one up, one down. Rule 15 is not engaged because the situation, as in terms of priority, is dealt with solely by Rule 9. Each vessel keeping to her starboard side of the channel and therefore passing port to port. So the priority will always be dealt with. There is no question of stand on or give way because they're both proceeding on their own side of the channel in a different way. My lady.
Could you help us at some stage with the question whether the situation you are now considering could ever actually arise on the facts of this case, given that we're dealing with two very large vessels of very substantial length? Could they both together be in the channel? At some point, if you think it's possible to help us, I should be obliged.
Certainly, my lady.
As it goes to the question whether or not one was waiting outside and what it was waiting.
Yes, my lady, thank you. I will address that point.
There may be some regulations about it.
Thank you, my lady. So that is Proposition 1 of the Empire Brent. Proposition 2, my Proposition 2 is that crossing rules remain applicable within a narrow channel where one vessel is proceeding along the channel and the other vessel is not, but is doing something different, for example, crossing. And the cases underpinning the second proposition are important because although they consider various different types of factual case, the cases demonstrate that where the factual situation is not that of both vessels proceeding one up and one down along the course of the narrow channel, and where a crossing situation is created by that navigation, then the crossing rules apply with full force just as much within a narrow channel as they do in open waters where there is no channel. Just because the vessels are navigating within or by reference to a narrow channel does not lead to the disapplication of other collision rules, including critically the crossing rules where the vessels are crossing. One's already seen one example of that, which is the Empire Brent, which deals specifically with vessels crossing a channel as an example given where the rules, crossing rules, will apply in conjunction with the narrow channel rule. Two other cases by way of example. Firstly, the Leverington, which the court will find at the electronic bundle reference CV, page 408. And I think the court is there. If anybody is not, please put a hand up.
The assessors have a problem, I think.
Yeah, could you just tell us the page number in the paper bundle, because we don't have the electronic one, we have the paper version.
Captain, it's the same page number, but it's page 408 in Authorities Volume 1.
Blank 10, I think.
So if I can go to the Leverington at page 408, and again, that's a very clearly described in the head note. A collision occurred at the junction of the main channel leading to Cardiff Docks and the channel to the Roath Basin, between a steamer going up the former and another coming down the latter, and held that the place of the collision was a narrow channel within Article 21, which was the old form of Rule 9, and that Articles 16 and 22, respectively 15 and 17 nowadays, were also applicable, there being no special or local rules to supersede the general rules of navigation.
Mr. Rainey, I find were you actually reading from your page 408 or 409? Because in every case, I find that the beginning page on authority is a blank sheet.
But my blank sheet has a page number, 407.
And mine has 408. I think I may be one page apart from everybody else for some reason. Anyway, I can cope. I just need to know.
Is everybody else in that position? In which case, I will simply add one and try to remember to.
I'm in the same position as Lord Briggs.
I think Lady Arden is saying she has the same as me. But
Lady Arden was muted for a moment, I think.
Sorry, I beg your pardon. I have the same page number as Mr. Rainey.
Oh dear.
Okay, well, what I will do is I'll give my page number and then I'll add one if that's full course.
At least it's only one out.
Yes, which is helpful. Or well, possibly not helpful, but at least not as bad as it could be. So, I mean, if it helps, I can give once we're in the case, I can give the reference to the page number in the case. No, okay. So, if we turn on to page 409 or 410, we see the judgment of Lord Herschel, the Lord Chancellor. And if we turn on to the next page, 410 or 411, at the top of the page, he says this: we are further of opinion that Article 16 is applicable to the present case. Though these are narrow channels, still the general rules of navigation apply so far as practicable to such places, and that in our submission is important. No other special rules being provided, as in the case in some rivers. One of the aspects of the Canberra Star, a case relied upon below, was that concerned the special rules in the River Thames, the Port of London Authority rules. That being so, and these vessels being crossing ships, it was the duty of the Leverington, which had the Rapid on her starboard side, to keep out of the way of the other. So that's a good general statement of principle that it doesn't matter whether you're in a narrow channel situation. If there is a true crossing situation, the crossing rules apply as well. And Lord Esher, Master of the Rolls, formerly Sir Balliol Brett, Admiralty Judge, said as follows: these two ships were in a narrow channel, so that Article 21, our Rule 9, was applicable. The question which arises whether Article 16, Rule 15, as is now, was not also applicable at a particular point in these transactions. That rule must clearly apply in a narrow channel if there are no special rules applicable to it. Instances might easily be given where a smaller river joins a larger, as the Medway joins the Thames, where vessels would be constantly crossing and where the crossing rule would apply. So it's simply looking at where people are joining the channel and then going across it. It is well that we should clearly lay this down, so that in the future, when vessels are at the point which was the place of the present collision and at similar places, there may be no doubt as to their respective duties. And again, that's important, saying that the crossing rule should be made clear to apply in crossing situations, even in narrow channels. And Lord Justice Fry rather shortly said, I think that Article 16, the crossing rule, applies in narrow channels, and it would be unwise and incorrect to hold that it does not apply in such places. The importance of these judgments are that they contemplate both sets of rules applying without any inconsistency. And one sees that actually being applied in an earlier case, the decision in the Ashton decision of the Admiralty Judge Sir Gorrell Barnes, Mr. Justice Gorrell Barnes, which is at 330 or 331. Sorry, I said it was a later case. An earlier case, it's a later case. It's 1904. This concerned a vessel inward bound to Grimsby, King Stephen, which was in the channel, and another vessel, the Ashton, which was outward bound from Grimsby, which was crossing the channel. And in the head note, one sees that the vessel in the channel, King Stephen, was found guilty of two breaches of the collision regulations. Firstly, held the plaintiff's incoming vessel, that is the King Stephen, was in her wrong water. So she was in breach of Article 25 of the then regulations, Rule 9A. So she wasn't keeping to her starboard side, breach of the narrow channel rule. Secondly, the head note goes on, dealing with the defendant's vessel, the Ashton. The Ashton was a crossing vessel, and therefore the Ashton was under the crossing vessel's duty, with the King Stephen on her starboard side, to give way. So the crossing rule was applied to her as the crossing vessel in the narrow channel. But towards the bottom of that second summary of the finding, about 10 lines up, where you see the words clean S boy, the judge, the head note says she should have waited until the incoming vessel had passed, that's the King Stephen, whilst that vessel, so that's the King Stephen, instead of porting, he went to port, should under Article 21, which is our Rule 17, obligation on the stand-on vessel, should have kept her course and speed. So this is a good example of the crossing rule being applied to the stand-on vessel, where the stand-on vessel gets it wrong twice. One, she doesn't comply with her obligation under Rule 9A. Two, she doesn't comply with her obligation under Rule 17A1 to keep her course and speed, without any inconsistency being suggested between those two rules. And if the court turns on, in the judgment of Mr. Justice Gorrell Barnes, one sees at the top of page 337 or 338, sorry, if I can just start at 335 or 336, the paragraph starting at the bottom of that page with the words, now the case involves. So 335 or 336. Now the case involves the consideration of certain of the rules applicable to the navigation in this locality. Amongst them are the starboard hand or narrow channel rule and the crossing rule. So he's applying them both. No suggestion to Sir Gorrell Barnes that there is a sort of clash here, which means it must be either or in a crossing situation involving a narrow channel, because it puts the stand-on vessel in an invidious position or the give-way vessel in an invidious position. And he goes over the next page and a half to deal with the King Stephen as the vessel in the channel coming downward. And he finds at the top of page 337 that the vessel was 8 lines down, was wrong in being in the position in which he was. So that's the starboard hand rule or the narrow channel rule applied. The next paragraph on page 337 or 338 is the crossing rule. And the judge says the next matter to consider is whether the crossing rule comes into force in this locality. The impression which I have formed is that it does. The traffic going up and down the river has to go past, in this locality, the traffic coming out of Grimsby, which has, speaking in general terms, to go across it to get into position. Just pause there. So what the judge is contemplating is that trawlers coming out of Grimsby have to go across the channel to get into position in the channel. And therefore vessels at certain times and places seem to me to be necessarily to be in the position of crossing vessels. And then he finds at the top of page 338, 339, right at the top of that page, if the crossing rule applies, it is quite clear that the King Stephen had no business to port at all. She had to keep her course and speed, and then he considers what would have been the position if the rule hadn't applied. And then dropping down to the bottom of the page, he then considers the application of the crossing rule to the Ashton, which was the trawler coming out of Grimsby, going across the channel so as to be able to use the channel later. The question remains whether the defendant's vessel is also to blame, and then he finds that she failed to give way. So the Ashton is a good example of both Rule 9A and Rule 17A1 applying to the stand-on vessel, and Rule 15 and 16 applying to the give-way vessel in a narrow channel in a crossing situation, even where a vessel is going across the channel so as to be able to use the channel. I.e., she's having to track across the channel to be able to get into it to use it. A very close situation we would submit to the Alexandra one outside the channel. The last authority case law I want to take you to on Preposition 2 is the Glenfalloch, which is at page, I'll just take you to the page where the dictum is, because the facts don't concern us, which is at page 385 or 386, depending on your numbering. And it's a decision of Mr. Justice Brandon.
I think what's happened, Mr. Rainey, is that the electronic number is one out from the number that actually appears printed on the page.
Ah, that's helpful. Well, given that my Lady Arden needs, I'll have to do, if it's not cumbersome, I'll just give the two numbers just to highlight.
Thank you.
So if it's at 385 or 386, and it's in the first column of that page, and it was argued that the we might just pick it up at page 385 or 386, right at the bottom of column 2, where Mr. Justice Brandon identifies the question. Right at the bottom of column 2, he says a question was raised as to which of the collision regulations applied to the case. I understood it to be common ground that the Araco channel is a narrow channel within the meaning of Rule 25A, so Rule 9A now. And then he considers whether it would make a difference to the various vessels involved. And then in the fourth paragraph in column 1, he says this: in my view, we're now on page 386 or 387, in my view, where one ship is proceeding along a channel, narrow channel in one direction, and another ship is proceeding along the same channel in the other direction, even though their courses are crossing so as to involve the risk of collision, the narrow channel rule governs the case and not the crossing rules. Kaiser Wilhelm de Gorsa, the Herhanger, the Empire Brent. If one of the ships is not proceeding along the channel at all, but crossing more or less directly from one side of it to the other, then the crossing rules may apply. See the observations of Mr. Justice Wilmer of the Empire Brent. They may also apply where there is a junction between one channel and another, and the two ships concerned are in the first place proceeding along different channels so as to meet at such junction Leverington. And, my Lord, the court may have noticed that the respondents in their case at paragraph 70 highlight the use of the word may. In our submission, that doesn't add anything to the considerations of the authorities. Mr. Justice Wilmer in the Empire Brent was plain that the rules have to be applied. The court was plain in Leverington, the rules have to be applied. And Mr. Justice Brandon was not saying, well, they may or they may not. It depends on the facts. He is summarising the Empire Brent and agreeing with it. And then lastly, on Proposition 2, if I can take the court to an extract from Captain Cockcroft and Captain Lemaire's book, one of the standard collision texts, standard guides to the rules, which is in the electronic bundle at page 940 or 941. And as I mentioned in my introductory remarks, these commentaries are commentaries that were on the bridge and in the wheelhouse, all sorts of vessels. So at page 940, the authors deal with Rule 15, which we know, the crossing situation. And then under the heading crossing in narrow channels and traffic lanes, because the same position occurs in relation to traffic separation zones under Rule 10. Power-driven vessels in a crossing situation in a narrow channel or traffic lane must normally comply with Rule 15, but all vessels are required to avoid crossing a narrow channel if such crossing impedes the passage of a vessel which can safely navigate only within the channel, Rule 9D. And then the next paragraph, although vessels proceeding in opposite directions in a bending narrow channel, my Lord Briggs's point, may come into a crossing situation, Rules 15 and 17 do not apply. Each vessel must comply with Rule 9A and keep as near to the outer limit which lies on her starboard side as is safe and practicable. So that is proposition 2. So if you have a crossing situation within the narrow channel, then Rule 15 applies as well as Rule 9. Proposition 3 is the extension of Proposition 1, the Empire-Brent situation, where one vessel is in the channel coming out, and the other vessel is entering the channel coming in, or is on her immediate inbound approach to enter for coming in. And in our submission, before coming to the cases, it's important to note the limited nature of this extension and the reasoning which underpins it. While a channel as shown on a chart may end abruptly at a pair of breakwaters or a pair of buoys, as here, the up-down keep to starboard requirement of Rule 9, which is applicable to vessels once they are both actually proceeding within the channel, up it, down it, along the course of the channel, has been held to extend outwards beyond the channel by extension. So that by analogy with the rule within the channel, for vessels proceeding along the course of the narrow channel, a vessel which is not yet in the channel, which is entering it or on her inbound passage so as to enter it on its way into the channel, is in the vicinity of the channel entrance treated as effectively being within the narrow channel. That's how it's put in some of the cases. Some cases put it another way. The channel is treated effectively as extending outwards to the vessel which is entering it and which is on her immediate entry inbound passage.
Mr. Rainey, I'm sorry to interrupt you. I think there may be a problem in that the assessors are using bundles which only go up to page 292.
Ah.
That's correct, is it?
Yes.
Yeah. And you're working off the hard bundles?
Yes, we are.
As opposed to the electronic copies?
I suspect that may be that the assessors have not been provided with the authorities bundles. I don't know why that is, because 292 is the end of the core volume, which are the cases and the judgments.
Yes, that's exactly what's happened. And indeed, the rest of the court, the members of the court, have not been supplied with the hard copies of the authorities.
Right.
So is there any possibility that the assessors could use the electronic copies?
That's not a problem.
I'm sorry, that's not... It's possible, is
If you
it?
can give us access to them, that would be fine.
If we can give the...
Access to them.
I will ask my solicitors who are listening to send to the registry the link to the electronic bundle now, so that the assessors can tune into the, if I put it that way, tune into the electronic authorities bundle. Does that assist me?
That would assist great. That would assist greatly. I mean, indeed, the registry should be able to forward all the volumes electronically to the assessors and understand what's gone wrong.
Thank you.
Should we take a moment or two? Should we just take a moment or two to try and sort this out?
Yes, my lord. If that's a good moment to take the 12 o'clock break, let's take the 5 minutes, my lord.
Yes, we'll take 5 minutes at this point, and we'll try and sort this out.
Thank you, my lord.
Thank you very much. Mr. Rainey, we're going to resume the hearing now. The unfortunate fact is that during your submissions this morning, the assessors did not have available to them copies of the authorities. Clearly, your submissions have been disrupted, and you must be allowed extra time to make up for that.
Thank you, my lord.
How would you like to? Do you want to recap over the submissions you've already made? The assessors have indicated that they were able to follow the submissions that you were making because of the summaries of the cases which appear in your case.
Yes. I think, my lord, the most convenient course, as we haven't really got going on the authorities yet, and I've only really referred to, I think, 4 or 5 short extracts. The easiest thing would be if the assessors were to read those to themselves, and if they need me to recapitulate my submission in relation to them, I'm very happy to do so. But I think my understanding was that they'd followed the argument and that they'd listened to what I was reading out from the judgments and were able to put that together as what I've said in my case about the judgments. In those circumstances, as there are only 5 citations so far, that might be the easiest and most expeditious way of dealing with it, if it's agreeable to your lordship and the court.
Thank you very much. They will also have access to the recording, of course, of your submissions.
Yes.
The assessors wish to raise a point?
Yes, my lord, no, that's fine. The only one that we could have, if you could just repeat the reference to Cockcroft as to the page number for Cockcroft, please.
Yes, certainly. The reference to Cockcroft was at page 940 or 941, depending on the bundle you're working off. I suspect as you're on the electronic bundle, you may have 941, but it's the section directly under the heading Rule 15, crossing rule. And then I was referred by Lord Briggs to another passage in Cockcroft and Lamar, which I will also be referring to, and that can be found at page 942 or 943, depending, under the heading Vessel Stopped. And that's in relation to issue 2.
Thank you. Mr. Rainey, I suggest we resume now and that you continue until about 10 past 1.
Thank you very much, Lord.
That's convenient. Thank you. And then
for the indulgence. Thank you.
We'll see that you're not disadvantaged in time.
Thank you very much. So I was explaining proposition 3 and that it applies effectively by analogy with the position which governs the position which applies to 2 vessels within the channel, where when one vessel is in the channel and coming out, another vessel is outside the channel and coming in, the vessel coming in is treated as if she's already in the channel, or the channel is extended out to meet her. And the rationale for that, as we'll see in the cases, is continuity. If Rule 9 applies to the situation where both vessels are proceeding along the course of a narrow channel and are in it, it has also been held to apply to the situation where one vessel is in the channel coming out and the other vessel is already in the process of entering it on her channel course and is coming in at the entrance to the channel. But as we will submit, the cases are confined to that situation where the vessel outside is proceeding on her channel course for entry into the channel and to proceed, in the words of Rule 9A, along the course of the channel. Therefore, it has no application to vessels which, for example, are not yet in a position to enter the channel and which are manoeuvring in some other way, for example, by proceeding across the channel or athwart the channel entrance. And for such a vessel, the rationale of continuity and extension has no application. She's simply a crossing vessel. She's no different from the trawler coming out of Grimsby, the Ashton, in the decision of the Ashton, going across the Humber, not along it or down it, but crossing it in order to turn then and to join it. And it's important we would submit, when we look at the cases, to note this is not a vicinity test. The Admiralty judge, as we'll see when we consider his judgment, acceded to a submission that things are different at the mouth of the channel because you're in the vicinity of the channel. The extension, which has been worked out in the cases, is an activity test. It's looking at the vessel which is outside the channel and asking, is that vessel, what is it doing? Is that vessel actually now entering the channel as a vessel coming in, so as effectively to be as good as being in the channel for navigational purposes? The cases I wanted to refer to are, and I hope this doesn't create another bundle problem, are first of all the Kaiser Wilhelm de Grosse at the first instance decision of Mr. Justice Gorrell Barnes, and that is in a supplementary authorities bundle, which I hope has also been provided to the assessors electronically, and that is supplementary authorities volume, tab 2, page SAV 8, and I hope SAV 8 is the first page of the report.
Yes, but the assessors have that. Can I ask the assessors, do you have this authority?
Yes.
Thank you.
Yes, Mark.
So this was a set of facts where a very large liner, the Kaiser Wilhelm de Grosse, was on her way out of Cherbourg Harbour between breakwaters, 2 breakwaters either side, and the steamship Orinoco was coming in. And the question was whether the crossing, the narrow channel rule should be applied in those circumstances. And the first instance decision is valuable because it sets out an earlier decision of Mr. Justice Gorrell Barnes, which he relied upon in reaching the decision which he did, which was upheld by the Court of Appeal subsequently. And so if I can ask the court to turn to the bottom of page 9 in the argument of Mr. Aspinall, KC, he was arguing that the crossing rule was inapplicable. And then over the page, at page 10, he refers to the narrow channel rule, Article 25, which is in effect the guiding principle in such a locality, i.e. between 2 breakwaters. And he says this: the same question arose in the Knaresborough, which was a case of collision in the Great Bitter Lake forming part of the Suez Canal. Great Bitter Lake is effectively a large expanse of water in between 2 branches or 2 ends of the Suez Canal. And the footnote sets out the decision of Mr. Justice Gorrell Barnes in the Knaresborough. And I won't take the facts, but if I can ask you to look at column 2 in the footnote quotation after the words "the elder brethren." The elder brethren take the view, and I agree, that the place where the collision happened was a narrow channel in the meaning of Article 25. For where a collision takes place just outside what is a narrow entrance, and at a spot where both vessels must act for each other, having regard to the narrowness of the channel, the one coming out and the other going in, and they meet at a point where their navigation is governed by the fact that one is to go in and the other is to come out from that narrow channel, it seems to us that that piece of water where they meet, although it may be a piece of open water, is governed by the rule applicable to the narrow channel. And the important thing to note about that is that he's defining it in terms of a vessel coming out and a vessel coming in, where they're navigating by reference to the narrow channel specifically, and their navigation is governed by the fact that one is going out and one is coming in. So dealing specifically with an entering case, because the Orinoco was entering, just as the Kaiser Wilhelm de Grosse was coming out. That argument was resisted by Mr. Pickford KC for the Kaiser Wilhelm de Grosse, but Mr. Aspinall picked it up again at page 12, which establishes that this must have been established by earlier cases which we no longer have available, because he says whether this is in the middle of the page, whether this was a narrow channel or not, the observations of the court in the Knaresborough apply, for the adjacent water is included in the narrow passage. Now, what does he mean by that? In our submission, he means that it is included in the narrow passage by simply dotting it out a little bit so that the vessel which is coming in to the channel is treated as being in the channel. Just as Rule 20 of the Tyne bylaws has been construed for the purposes of navigation, it's a case we don't have, to include some portion of the open water outside the pier heads. And in the decision of Mr. Justice Gorrell Barnes, the relevant part can be found at page 16. And at the bottom of the first paragraph, after saying he does not know that it is necessary to express a definite view about the application of Article 25, that's Rule 9, the narrow channel rule now, but I must say my own inclination is to think, in accordance with what I said in the Knaresborough, that the rule ought to be taken as applicable to the passage, i.e. the passage of the two vessels, between these two piers, and so much of the water adjoining as was necessary for the negotiation of the channel, i.e. by one vessel coming in, the other vessel going out, at that spot. And therefore, the narrow channel rule applied, and the vessels were to pass port to port, even outside the narrow channel itself. And the Court of Appeal's decision is at the main authorities bundle, or the main bundle, at page 393 or 394. And he said, starting at the bottom of page 393, 394, counsel for the appellants strenuously argue that Article 25 did not apply on the ground that this was what they called an entrance or an opening and not a narrow channel. I cannot think that such a construction ought to be put upon the word channel. And then he goes on to say that it applies wider than that. To put an instance, we know in approaching an opening between buoys or between light ships, there may be dredged channels. It seems to me very dangerous to suggest that the obligation to keep on the starboard side for the purpose of navigation should depend on there being or not being a dredged channel of considerable length. And I think it could be seen even from a landsman's point of view that a place like the neck of a bottle may be a place involving exactly the same risk, again, to vessels coming in and going out as a longer neck or channel, and therefore the narrow channel rule applied. That's the Kaiser Wilhelm de Groote, both at first instance in the Court of Appeal, and that was relied upon by Mr. Justice Clark, Lord Clark, sorry, in Culemessin, as we'll come to.
I think Lord Briggs has a question.
Yes, Mr. Rainey, it might be said that the judge at first instance is dealing with a situation where there's an assumed narrow channel and asking himself where its consequences end. Whereas the Court of Appeal was dealing with a more fundamental submission, namely whether the space between the two breakwaters on the western side of Cherbourg Harbour were a narrow channel at all.
My Lord,
I thought was the main issue in the Court of Appeal.
My Lord, I accept that. The argument seems to have shifted by the time it got to the Court of Appeal, which is why...
The argument's got more extreme by the time it got to the Court of Appeal.
It has, perhaps recognising that the dot extension principle is difficult to get away from. So it's easy just to say, with one bound I am free, it isn't a narrow channel at all. And that appears to have been to get out of the Knaresborough situation. But your Lordship is entirely right, which is why in the next case I'm going to take you to, the case the court cites both the first instance and the second instance decision, and that's why I thought it necessary to show the court how Sir Gorrell Barnes applied it.
Am I right in thinking that the Kaiser Wilhelm de Groote is the only one of these cases about your concept of extension, where the collision actually occurred outside rather than inside the channel?
Yes, my Lord.
Yeah, thank you.
So if the next authority is the Treherbert, and if I can ask the court to turn in the authorities bundle to 923 or 924 in the judgment of Lord Justice Greer, and I can take this case a little more shortly because the Court of Appeal found that it wasn't a narrow channel at all. This was an even more ambitious submission, where it was being argued that all the water between the North Foreland and the German coast was a narrow channel, an argument which was rejected with some asperity by Lord Justice Scrutton. But we don't need to consider that aspect for this appeal, but what we do need to consider is the summary of the position by Lord Justice Greer, which is why the Treherbert is cited in the books and in other cases. And at 923 and 924, Lord Justice Greer says in the bottom paragraph, now it's quite clear and beyond argument that in the ordinary sense of the word, this collision did not take place in a narrow channel. And here, to pick up my Lord Briggs's point, The argument then was clever. They thought, right, well, if we can't establish it's a narrow channel, let's say it's an approach. And so the argument, when he said a channel with only one side that indicated cannot by any stretch of language be described as a narrow channel. But it is said that there are authorities which show that a vessel which is approaching a narrow channel may have to take the same kind of action, having regard to the need for skillful navigation, as she would take if she were actually in the channel. That I take to be the effect of cases like the Kaiser Wilhelm de Gorsa, and you see that he cites both the first instance and the Court of Appeal decision, where the vessel was just approaching the place where she would have to go between two moles and into a narrow channel, and where it may very well be that good seamanship directs that the position is to be treated as if she were already in the channel and not treated as a case of crossing ships. But these decisions have no application whatsoever to the present case, where the vessels were a very long way from anything that could be described as an entrance to a channel. The object of Article 25, that's Rule 9, applying to narrow channels is the same as the object of the crossing rule. It is in order to secure that vessels shall pass port to port. It is secured in one way by the crossing rule. It is secured in another way by the provision in the narrow channel rule that each shall keep on her own starboard side. And my lord, the important aspect about that case is the vessel is effectively navigating in a course that proceeds along the channel, outside it, on her entry to it, and therefore she's to be treated as if she were already in the channel. So the crossing rule doesn't apply, and effectively it's a ... extension of the channel out to meet her. That's proposition 3, which shows that there is a limited extension of the Empire-Brent principle in that sort of entry case. Proposition 4 is that the crossing rules remain applicable to vessels navigating outside a narrow channel, but not entering it, and a vessel proceeding within the channel. And the authority I rely upon here is an extract from Marsden, now Marsden and Galt, on collisions at sea, which is at page 965 or 966 in the bundle. So it's paragraph 5-302. And this is a text of some antiquity. It stays since the 7th edition of 1919. We haven't gone back earlier than that, and therefore it's gone through quite a number of editions. Relationship with other rules. Difficulty has arisen in regard to the application of the crossing rule as between vessels proceeding along a narrow channel and those approaching the narrow channel with a view to proceeding along it. It would seem that where in such circumstances both rules may reasonably be complied with, obedience to both rules is incumbent upon the vessels. Thus, where ship A, being in Cardiff Drain, was required by the narrow channel rule to keep on the starboard side, and the other ship B was in the entrance channel to the Roath Basin, it was held that they were crossing ships, and that A, having B on her starboard side, was required by the crossing rule to keep out of the way, the Leverington. So there is a ship going to join the channel, but joining it from a side channel. So also, where two vessels were rounding the Clean S Buoy, the one bound from Grimsby to the sea, and the other from the sea to Grimsby, the incoming vessel was held at fault both for being on the wrong side of the channel and also for not keeping her course and speed, and the outgoing vessel was held at fault for not keeping out of the way. And those are the facts of the Ashton, where we know a vessel was crossing to get into the channel from within the channel. She was coming out of Grimsby, go across to go down and into the channel. So in our submission, that is a good statement of the position. Unless you're in the channel, or unless you're within the limited extension principle, the crossing rule applies in a crossing situation. Why shouldn't it? You're crossing. Proposition 5.
Burrows?
I'm sorry, I've just lost the reference. I apologise. Could you just give me the reference again?
I'm sorry, my lord.
The electronic reference, I'm sorry.
Certainly. It was 965, my lord, or 966, paragraph 5-302.
Thank you.
My lord, Lord Briggs.
In my bundle, it's at 974. There's something further that's gone wrong with the. Luckily, I've got Marsden in hard copy, but in my electronic bundle, 5/302, which is the paragraph you're referring to, is at 974.
That is very bad news, my lord.
I know, I'm very sorry to have to tell you.
I don't know how that has happened or what has happened, who is affected by it or how to deal with it. But I'll do my best. I think, does the court have tabs to the bundles in the electronic bundle?
I'm afraid we don't have any hard copies at all. We have electronic bundles.
Do the electronic bundles have a tab?
But it's paragraph 5300.
5-302.
302, yes.
Yeah. Mr. Rainey, what they do have is an authorities index with hyperlinks. So if all else fails, one can go to the authority you're referring to in the index and then just click the hyperlink and you're on the front of it.
Thank you very much, my lord.
And the index is at page 290.
Thank you. But I will see why that's happened, and so that I can readjust my notes over the short adjournment for issue 2. But I'm afraid I am where I am for issue 1, so I'll do the best I can. Proposition.
Sorry, before you go there, just to be clear, can you just explain to us how you draw the line between situations 3 and 4?
Yes, my lord. The line is drawn where the vessel is entering the channel. That's a proposition 3 case, or where the vessel has actually and is actually shaping on her entry passage course. And I'll give you 2 examples of that in relation to proposition 5, the Canberra Star and Cula Messin. And so there will be a factual judgment to be made as to whether the vessel is entering or on a course to enter, or is in fact doing something else preparatory to entering and preparatory to taking up a course to enter, which is important, because otherwise the extension principle, the continuity principle, applies literally to any vessel which is somewhere in the region of the channel mouth, wants to go into the channel and is preparing to go into the channel, isn't yet going to the channel, and is actually crossing it because she's not yet in a position to go into the channel, which is the position of the Alexandra 1.
As I understand it, Mr. Rainey, these rules are intended to be readily applicable to circumstances under observation.
Yes.
How easy is it going to be to distinguish between these 2 situations for the other vessel?
My lord, in our submission, it will be, well, it depends upon the facts, but it will ordinarily be easy to establish whether the vessel which is ahead of you is coming, as it were, at you, entering the channel on an entry course, or is actually going across you, because you watch her bearing, is her bearing altering or not? What is she doing? Where is her movement taking her? Is it taking her towards the channel mouth, or is it taking her across the channel mouth to the centre line of the channel, which is what the Alexandra 1 was doing? So it will always be a question of observation. So, for example, if you take the facts of the Ashton, when it joins the channel, would have to be observed carefully. What is she doing? Is she going to cross the channel, or is she going to do something else? And when observation shows that she is crossing rather than entering, then you're in a crossing situation.
Isn't it more difficult in a situation where the vessel is shaping to enter the channel, where you would say that the crossing rules would not apply? It might be very difficult to ascertain whether a vessel was actually shaping. So take the facts of this case.
Well, the facts of this case and can be contrasted very usefully with the shaping case, which is Cula Messin. It depends what you mean by shaping. Shaping to enter, in our submission, looking at the cases and reading them carefully, means on your entry course and making just those corrections of course to keep yourself on the course for going in on your side of the channel, starboard side too. It does not include somebody who's not yet in a position to enter the channel and is actually allowing herself deliberately to miss the turn and to drift across the channel. And there will be distinctions. There will, of course, be factual distinctions. But that is why the crossing rule is applied in a narrow channel where vessels cross. If this vessel is not actually akin to a vessel in the channel and is not actually akin to a vessel entering the channel or on her entry course into the channel, which is what shaping means, and is still outside, then the extension doesn't apply. The rationale for continuity doesn't apply.
You say that that distinction would have been apparent to the Eversmart?
Yes, it would have been apparent to the Eversmart, because the Eversmart would have seen the red light of the Alexandra 1. Her radar would tell her, as it did, as we'll see on the video, which you'll see this afternoon, that it was a bow cross situation, and could see that she was going very slowly and was actually tracking across the starboard side, side of the channel she should enter to the centre line. That if and the lookout on the Eversmart wasn't very good, but if the lookout on the Eversmart had watched the Alexandra 1, they would have seen she was not shaping to enter the channel, but was actually slow, going across the channel, ending up towards the centre line of the channel, and not turning, as the judge found, not turning where she should have turned, that being the deliberate decision of the master, but that would also have been observable to the Eversmart. The Eversmart would have said, well, look, what is she doing? I must watch her now carefully. Is she making her turn to starboard to enter the channel? Or is she doing something else? And she was doing something else, and that would have been observable. Namely, she's not turning where she should turn, where she'd be expected to turn. Instead, she's going across. And in those situations, she's a crossing vessel. Because the vessel that observes doesn't then know, it can only judge the navigation which it sees, doesn't then know what the Alexandra 1 is going to do. The Alexandra 1 could have done a number of things. She could have continued to go right across, waiting for the pilot, and then done a turn to port and come round and come down from the channel from above. Or she could have continued right across and not made any turn. On the observation of the Alexandra 1, she was crossing. She was not entering. And there may be situations where it may be difficult to tell, but in our submission, this case wasn't one of them. But then there will always be situations in a straightforward crossing rule case, take it away from a narrow channel at open sea, in open waters, where whether you are crossing or not, or whether you have actually already crossed, and whether you are crossing with the risk of collision requires careful judgment and observation. But in our submission, the extension principle is not undermined or needs to be extended, because it's difficult to tell when a vessel is crossing across the channel rather than coming in. In our submission, it's not.
There comes a point in the course of the Alexandra which it becomes apparent that she's crossing and the crossing rules apply.
Yes. And I mean, our case below, if the crossing rule is held not to be disapplied as a matter of law, is the crossing situation applied from about C-20, when the vessel, as you'll see on the video this afternoon, is effectively on a course which is taking it towards the channel, but not entering it. And in those situations, the crossing rule applies from that stage.
So is it
Lady Arden has a question, and then Lord Hamblin.
Very much. I was just going to say it may be relevant to consider my question this morning, earlier this morning, in this connection. But we do know at least that the ship could not proceed without a pilot, and that the pilot had only just started his journey from Buoy 6 to get up to the A1. That would also be a matter of, perhaps not of observation because it was dark, but would be known to the master of the ES. And the master of the ES could also have telegraphed, or whatever you do, communicated with the ship?
Yes, well, VHF communication is usually not favoured as a means of collision avoidance, because it usually leads to more collisions than it avoids.
But as this case graphically demonstrates.
Graphically demonstrates, and as the case is laid out, the course you should follow is to follow the rules.
Yes, but my point this morning, if there is an answer to it, would also be relevant if it's not an observation.
Yes, I'm looking at that, my lady, in the gap for the bundles that we dealt with. In terms of dimensions, the channel is 2 cables wide, 360 metres, and the two vessels were about 40 to 45 metres each in beam.
100.
So theoretically, it would be possible for both vessels to use the channel at the same time. An aspect which hasn't been considered is whether that was actually permissible, and your ladyship has put a finger on that point, and whether therefore the Alexandra one was really a vessel in preparation for entering, because she could not be entering, because either she wouldn't be allowed to enter when the other vessel was in it, or she couldn't enter it because there was only one pilot, and until that pilot reached her, she wasn't going anywhere except drifting across the channel mouth. I mean, I appreciate the where your ladyship's question goes with that, because that then alters the position. But I'm informed by Mr. Jacobs that nobody below, at least in the Court of Appeal where he represented the owners of the Eversmart, relied upon any local regulations relating to how many vessels at the same time and of what beam in the channel. I will continue to look at that point, my lady, and revert at 2:10.
Thank you.
I think my Lord Hamlet had a question.
Yes, so just going back to your C-20 point, does that correspond with when you say the vessel was not turning when you should have been turning if she was going to the channel?
No, that is when the vessel first comes in visual sight. C-24 is when they're first in visual sight, and for what you do, the rule applies when the vessels are in visual sight of each other. C-24, the vessels come into visual sight. You observe what the vessel is doing.
Right, so even at that stage, it's not a course that would be consistent with later turning into the channel. You're saying that the crossing rules are still applicable.
The crossing rule still then applies, because at C-20, you don't know whether she is actually going to enter the channel. And then the crossing situation is engaged, because she may continue to go on that course and go straight across without entry. You don't actually know whether she's going to be entering the channel at all. She may be steaming across the area, rather like the tow and the barge did, the Saké Bravo. You observe her, and if suddenly her course changes and she turns to starboard, then the crossing situation may well end, because now you're dealing with an entry, a vessel which you know from observation is entering. But it all depends on observation. She may do something completely different, which means there's going to be no risk of collision, in which case Rule 15 wouldn't be engaged. She may no longer be on a crossing course as she navigates. And the seaman has to observe and see what she's doing and see whether it changes from a crossing situation into something else. In this case, it never changed into something else. So it started as a crossing situation at C-20 approximately, when the Alexandra one would have been observable for about four minutes. And then she never really changed what she was doing. She continued to go across rather than to turn to enter the channel. So I think, does that answer my Lord Hamlin's question? My Lord Briggs, does he have a question?
Well, at some stage, Mr. Rennie, but please choose your own time, because the point may have different effects on issue 1 and issue 2. These rules, I think, as I understand it, are meant to be applicable as a matter of construction between vessels of all types, and in the context of this rule, power-driven vessels of all types, ranging from a small boat with an outboard engine to a supertanker and passing through an aircraft carrier somewhere in between. I'm concerned about an over-ready assumption that the rules should be construed on the assumption that at night, one vessel can understand what the track of the other vessel is, rather than merely whether it's on a steady bearing. Because the two things don't automatically follow from each other unless you apply software such as AIS, or the one that applies to radars, I've forgotten the abbreviation, which can derive a track from a series of repeated ranges and bearings. All the navigator with a hand-bearing compass in his little boat with an outboard engine can tell is whether the ship is on a steady bearing, and probably, because if it's at night, the lights will be getting brighter, whether it's approaching, which are the two parts of the test in the rule that determines whether there's a risk of collision. And my question for you really is, how far has the advent of radar track generation and AIS changed that basic problem of perception when two vessels are approaching each other at night? Don't answer now, but I think it's a question that affects both issues.
It has a particular bearing on issue 2. So
Yes.
As your lordship foreshadowed,
I'm coming to think it may also affect issue 1.
It has a bearing on
I'm wondering whether you're making assumptions from a plotted track, which we all have on the acetates, about whether somebody on the bridge of the Evergreen could actually tell what precise track Alexandra was on, albeit he could probably tell, if you join up all those dots with the same time, that she was on a steady bearing and approach.
It will be the aspect that the lights bear, my lord.
But the lights don't tell you anything from about 10 degrees off dead ahead to about 22.5 degrees above peak.
But yes, my lord, but then it depends on other matters. Can I come back to that, my lord?
Yes.
So I'm on proposition 5, which was that the no case suggests that a vessel which is not entering the channel and is not shaped to enter the shaped to enter the channel by taking up her entry course is nevertheless within the extension principle, and that it doesn't matter whether a vessel is navigating across the channel mouth, because she's in the vicinity of the channel mouth, then Rule 15 doesn't apply. And the court should have in mind what the breadth of the submission was before the judge. The breadth of the submission was that the crossing rules have very little to do with the vicinity of the channel mouth, and vessels which are preparing to enter the channel you don't need to comply with Rule 15. Rule 15 doesn't apply to them. And the approach taken by the judge, who was to look at it on a vicinity basis, do the crossing rules apply in the vicinity of the mouth? And our submission, that's completely wrong as a matter of principle. The two cases which are relied upon, the Canberra Star and the Kuna Messin and Hong Kong cases, I'll take the court to now, because they are, I think, are said to stand for the wider proposition that anything in preparation will do. In our submission, the proposition they stand for is the continuity principle which we've outlined in issue 3, proposition 3, and they show that the situation is restricted to vessels which are actually entering, coming in, and on their entry course, and no other vessel, which is, again, I think touches on the question that my Lord Hamblin was putting to me. The Canberra Star is the first of these decisions, a decision of Mr. Justice Hewson. And that's the authorities bundle, I hope, at page 360 or 361. And the facts of this case, which we'll look at in just a moment in more detail, can be summarised as follows. The City of Lions was an outbound vessel which was navigating off some moorings to enter a channel in the River Thames. The Canberra Star was an inbound vessel already in the channel and coming to the exit or the end of the channel. And in relation to the facts, so what we're looking at now is when does Rule 9A take over for the City of Lions, and when does it disapply Rule 15 for the crossing situation? What is the navigation that the City of Lions is engaged in, which puts her within effectively a Rule 9 situation, even though she's not yet within the channel? And the navigation is at page 363 or 364, column 2. And the City of Lions casts off from the explosive moorings, and she's going to the dredge channel between the upper and lower cliff buoys. She unmoors and she sees the Canberra Star. 10 minutes before the collision, she puts her engines to full speed. So speed is going to be important because you need speed to shape your entry course. A little after casting off her head, full speed, which when developed would give her about 10 knots. She's steadied on a course of 15 degrees true, so she's on her course for the channel, with the object of entering the channel close to the cliff lower buoy, which marks the end of it, and slightly to the westward of it, and from thence proceeding upon her outward bound voyage downriver, i.e. in the channel. In due time, having worked up to about 5 knots, the City of Lions reached the cliff lower buoys at the start of the channel, very close to on her starboard side. So she's taken up a course at full speed, which is 15 degrees true, which is aiming for the channel and to keep it on the starboard side of the channel, and she reaches the starboard side of the channel on that entry course. So she's an entry vessel, but she's also a vessel on shaping up to enter on the correct course for entry. And then she sees the Canberra Star, which is on the wrong side of the channel. And the argument, the way it was dealt with, is at page 364, 365. And we need to take this a little slowly because of the reliance placed upon it by the Court of Appeal and the Admiralty Judge. Column 1, just after halfway, Mr. Brandon. Mr. Brandon has argued, he was for the Canberra Star, which is on the wrong side of the channel. Mr. Brandon has argued there was a duty on the City of Lions to keep clear for 2 reasons. Firstly, that the crossing rule, Rule 19, applied. That's the only argument with which we are concerned. And then this. Now, as to these contentions, I want it to be very clearly understood that I am very far from saying the crossing rule never applies in the area of the River Thames covered by the Port of London River bylaws. It's fruitless to attempt to envisage all the possible combinations of circumstances, and I'm not going to attempt it. The judge then summarises the Port of London River bylaws, which include a starboard side rule, i.e. Rule 9, and then vessels crossing, and then Rule 40, which are vessels coming into the main channel from tributaries or creeks. And he finds that the City of Lions, although not bound strictly by Rule 40, was bound by that principle as one of good seamanship. Mr. Brandon, in the course of his argument, mentioned the Gulf of Suez. That case concerned the River Mersey, so another narrow channel case, because the River Mersey up to the Rock Light is a narrow channel, the material part of it being straight and comparatively broad. In the particular circumstances of that case, the crossing rule was held to apply as between a vessel emerging from the Albert Dock, so you've got a vessel in the channel but starting to cross across within the channel, and an upcoming vessel. That's rather like the Grimsby trawler in the Ashton. In the circumstances of this case, where vessel A proceeding downriver outside the channel intending to enter it, sees an upcoming vessel B approaching it in the next reach bearing on her starboard side, on a main channel course which, if followed into the reach in which A is navigating, will or should enable the 2 vessels to pass safely port to port by reason of the fact that B should keep to her own starboard side of the channel, and A will navigate into and keep to her own starboard side, so reflecting the fact that she was already entering it. The crossing rule does not, in my view, apply. The actions of vessel B should be governed by Rule 38, which was the starboard side rule, and A by the rule of good seamanship to which I have referred, and in due course by Rule 39. The rule of good seamanship for a vessel entering a main channel is that she should do so with caution and not hamper traffic already navigating in it. Vessels already in it, as well as those about to enter it, should behave reasonably and don't hog the river. And then he refers to another Thames bylaw case. And we would say about the Canberra Star 2 things. First of all, the case concerns an entry into the channel at speed, not preparation for entry, shaping a course to enter and entering, and therefore is a clear example of the as if already in the channel situation considered in the Kaiser Wilhelm de Groote in the Knaresborough and defined by Lord Justice Greer in the Treherbert. Secondly, the case needs to be treated with some caution, although it's been later taken as standing for a wider principle, because Mr. Justice Houston's decision was plainly bound up with the Thames rules and the Port of London River bylaws. But in our submission, one considers the navigation of the City of Lions and compares it with the navigation of the Alexandra I, the difference couldn't be more stark. The next case I need to take the court to in this connection is Coolamesson in Hong Kong. And that is in the bundle, I hope, at page 441 or 442. And the context of this case it needs to be borne in mind. There had been a tragic collision between 2 vessels in a buoyed channel. The Neftegas 67 was in the channel exiting, and the Yao Hai, much bigger vessel, was entering the channel. It was a criminal appeal, and the issue was, had the prosecution established there was no reasonable ground for belief held by the masters of the 2 vessels. The issue in relation to that, for the master of the Neftegas 67, was his belief that the Boyd channel was not a narrow channel, and it was held that was completely unreasonable, and his conviction was upheld. The issue for the master of the Yao Hai was his belief that Neftegas 67 would know that she was in a Boyd channel and would move over finally to starboard and do what she should do. That was held to be a reasonable belief, and the conviction was quashed. The core facts, for present purposes, can be seen from the chart which Lord Clark prepared or exhibited to his judgment as Annex 3 to his judgment, and which he refers to in paragraph 146. That chart can be found in our bundle. Can I ask you to, I don't know how this works with the electronic bundle. We'll have to come back to Kullermessen, but if I can ask you to go in the core volume to the chart from that case, which is appended to our appellant's case. And that chart should be at page 99.
Yes.
I'm just giving the court time either to open it up or to find it. You have here, again, a situation very different, actually, from the situation in our case. If the court sees in the middle, or the centre of the chart, a circle with two triangles sticking off it.
Yes.
That is a radio calling point for vessels going in and coming out. On either side of that radio calling in point, I only use it for orientation purposes, the court will see a black buoy, which is marked CP1, that's the green buoy. And then underneath that symbol, the circle with the triangles, another buoy, a red buoy, CP2. Those are the two buoys that mark the end of the Boyd channel, which the court held was obviously plainly a narrow channel. The black track, running from left to right, is the track of the Neftegas 67 coming out of the channel at about 10 to 10.5 knots. The red track, which we see going from right to left, is the track of the Yao Hai at 13.5 knots, shaping to enter the channel on the starboard side as it faced her. So she's on her channel course, and rather like the City of Lions, is proceeding at full manoeuvring speed for her entry course. And as the judge held, she was shaping to enter the channel with minor course corrections to get her in on the right side for starboard. So this, in our submission, when one considers the vicinity of the channel mouth between CP1 and CP2, is a classic entering case or shaping to enter case. And again, the navigation in our submission couldn't be more different in that being engaged in by the Alexandra 1, just slowly drifting across the channel rather than shaping up to go into it. And the importance of the decisions in the Kullermessen can be then considered when that chart is in mind. Can I ask the court then to go back in the bundle to the report and just identify first of all the issues which the court had before it, which is at page 486 or 487. And the particular issues which the court had to consider, these are the certified questions, were 2, what are the principles for deciding whether it's a narrow channel? The court's not concerned with that. 3, does Rule 9 apply to a vessel approaching but navigating outside a narrow channel with the intention of entering it? Now, pause and bear in mind what the facts of this case were. The Yao Hai was coming in at 13.5 knots on her channel course, intending to enter it. And then issue 7 on the next page, do the crossing rules apply when a vessel is approaching a channel on a crossing course involving a risk of collision with another vessel navigating in the channel? So that sets, as it were, the various issues, the same sorts of issues which the court is considering in this case, but with very different navigation. And if the court goes, please, to page 491 or 492, in relation to the judge's finding, this is in the judgment of Lord Clark, in relation to the judge's finding that it was a narrow channel, right at the bottom of the page, he considers a number of factors which he took into account. 158, and then a lot of the factors we're not concerned with. If you turn over to the top of page 492 or 493, little 4, little Roman 4, the object and underlying rationale of Rule 9. And the judge, Lord Clark, comments on what the judge said about that particular factor at page 494 or 495. And this, in our submission, is a valuable passage because it sets the context for what Lord Clark then goes on to find about the issues about crossing or not. Object and underlying rationale of the rule. The judge expressed her conclusions broadly thus, under the heading passing of vessels within this stretch of water. Vessels passing in the channel should pass port to port, with each vessel proceeding as close to her starboard side, as safe as is practicable. Under Rule 9, the vessel in the channel should plainly do so, because vessels entering the channel were expected to do so. Vessels navigating in the buoyed channel, seeing vessels approaching the buoyed channel in the opposite direction at an early stage, are likely to see a number of alterations of course of these vessels, as they may be constantly changing their aspect in order to shape a course into the channel. And then these words: safety requires a vessel approaching the channel so as to proceed along it, and those are the words of Rule 9A, to navigate so that if vessels pass from the channel, they will pass port to port. This will be achieved if the narrow channel rule applies. If it does not, there is considerable scope for confusion. So what the judge was finding, and what Lord Clark cites with approval here, is that if the vessel is approaching on her entry course, i.e. so as to proceed along the channel course, then Rule 9 extends out to her. And that effectively is the continuity principle, which the judge then referred to later on, which we'll now see. If we then turn on to the reasons which Lord Clark gave for the particular master's appeals, on the N67 appeal, at page 509, 510, right at the bottom, at paragraph 217, Lord Clark says this: having referred to the Empire Brent, which we've seen, which on its face applies to vessels in the channel, the judge said, basing herself on the evidence of Captain Simpson, that vessels approaching the channel, and we've seen approaching so as to proceed along it, and vessels within it must acknowledge that there must be some continuity, so that Rule 9 applied at the entrance to the channel in order to avoid chaos and ambiguity. So one's asking, where does the Rule 9 apply, and to what vessels doing what does Rule 9 apply? She referred to the decision of Mr. Justice Houston in the Canberra Star, where he said that, and this is Lord Clark's summary, effectively, of the Canberra Star, where he said that if a vessel is entering a channel to proceed along it, again, the words of Rule 9, which are important, and which were overlooked by the Court of Appeal and Mr. Justice Tier, in circumstances where there is another vessel already in the channel, the crossing rule does not apply. So effectively, the vessel which is entering it into the channel to proceed along it is treated as if she's already in the channel, because she's doing, by her navigation, what she will be doing when she gets into the channel. She's proceeding along the channel course, and she's doing it outside so that she enters the channel on the right course rather than the wrong course. And for that very simple situation, the channel rule extends out to meet her, or she's treated as already being in the channel. And Mr. Justice Lord Clark then said, that seems good sense to me. At 406 and 407, the judge held that N67 should not have assumed that the Yao Hai would leave the channel, but should have expected them to enter the channel on their starboard side of the channel, close to buoy CP1, and should have altered course. And then in relation to the Yao Hai appeal, at page 513, 514, the judge, Lord Clark, then applies the same principle now to the Yao Hai, which is the entering vessel. And we've seen from the plot how she was entering at 13.5 knots on her course to enter like the City of Lions on the starboard side of the channel. Paragraph 225, I have already concluded that the CP channel is a narrow channel. I've also expressed the view the vessels approaching a narrow channel and intending to proceed along it are not bound by the crossing rule but must enter the channel, and as they do so, keep as near to the starboard side as is safe and practical in accordance with Rule 9. And that makes perfect, pausing there, that makes perfect good sense. It seems to me to follow that a vessel shaping to enter the channel, and that means, I mean, he's talking here about the particular context of the Yao Hai, where the Yao Hai was on her channel course with minor course corrections to keep her on the right course for entering the channel starboard side in. It seems to me to follow that a vessel shaping to enter the channel should, as a matter of good seamanship, navigate in such a manner that when she reaches the channel, she's on the starboard side of the channel in accordance with Rule 9. The judge, in effect, so held and was correct to do so. This approach is consistent with that espoused in the Court of Appeal in the Kaiser Wilhelm de Groote. He cites Lord Alverson, Chief Justice there. As I read the report, the reference to the entrance was a reference to the entrance to a narrow channel. There might be a debate about that, question put to me by my Lord Briggs, but in our submission that doesn't make any difference to the principle which Lord Clarke is outlining. 226, as is plain from the plots, the Yao Hai in fact navigated in such a way as to shape to enter the channel in a correct position on her starboard side of the channel near CP1. Now, that's what he means by shaping. The Alexandra 1 was not shaping. So in our submission, the Canberra Star and the Kula Messin properly understood, and then seeing the underpinning of them in the earlier case of Kaiser Wilhelm de Groote and the Knaresborough, are dealing with vessels which are effectively a vessel outside, which is entering the channel in such a way as effectively to be treated as a vessel which is already in the channel, because she's proceeding on a channel course. My Lord Burroughs has a question.
Can I just ask you a question? Because it seems to me a lot of your submission is turning on what is meant by shaping to enter the channel. Does it make a difference whether you're entering east-west or west-east? In other words, whether you are nearest the starboard side or not? Because with one of those, you may have clearly to cross the channel, but you may be said, might you not, to be shaping to enter the channel. Are you then saying the crossing rule doesn't apply?
No, my lord, I'm certainly not.
No.
But the Court of Appeal said it didn't, and came up with a workaround. The east-west situation is a very, very good example of how this shaping to enter suddenly takes on a life of its own. You have a vessel which is having to go right across the channel, right across the path of the vessel coming up on this.
But assuming, are you saying it's impossible to regard that as shaping to enter the channel?
Well, my lord, it depends what you mean by shaping. There's no.
Well, that's what I'm asking.
It's a good question. It's not a technical or a legal term. It's actually sort of getting your course right to enter. But the shaping that Lord Clarke is talking about is actually lining yourself up for the right side of the channel.
But let me just give you then, go back to the position you were talking about, where you are envisaging that a ship is shaping to enter the channel, but has to come a long way across the mouth of the channel to do that. What are you then saying the position is?
And my lord, I would say, one, she is not shaping in the sense that Lord Clarke was referring to shaping in Kula Messin, because she's not on her entry course. Entry course means the course which is actually lining up to line up with your side of the channel. She's not yet in a position where she's in any way able to take up her entry course. She's got to go across the channel first and then line up. When she starts lining up, when she's across the channel, she may be shaping to enter the channel, but she's not shaping when she enters on the east side, when she's got to get all the way across to the west, then turn to starboard and start to shape to come down.
So that's what I'm saying to you. You're as a proposition saying you cannot shape up in that situation unless you have already effectively gone across the mouth and have got into a sort of area where you can straighten up to go in the channel. Is that the idea?
That's the idea, my lord. And that's precisely what happened. There's the facts of the Ashton, where the trawler, the Grimsby trawler, outward bound from Grimsby, was having to cross the channel to go into it. And to say, oh, well, she's shaping to enter it, even though she's having to go all the way across it first before she can take up her channel course. These cases are considering vessels that are already on the channel course with course corrections. That's the shaping. You may need to put it a little bit to port, a little bit to starboard, as you adjust, minor adjustments to get yourself onto your entry course into the channel on your right side.
So in that position, you just say the crossing rules would apply?
Absolutely. And in our submission, the east-west example, which the Court of Appeal had, with the greatest respect, considerable difficulty with, the east-west situation is a classic example of the crossing situation, where you now have the rules of priority completely torn up, with people having to try to work out by VHF, what are you doing? I don't know. What should I be doing? Rather than just saying, look, are you in the channel? No. Are you entering the channel? No. Are you shaping up on your entry channel course? No. What are you doing? I'm crossing the channel. You're a crossing ship. And that is the Ashton in our submission. And the east-west example, which I think was argued strenuously by Mr. Jacobs below, the east-west example is important to unpick it, because just take the submission that was made by Ms. Selvaratnam. It takes two to cross. I know that was in the issue, in the context of issue 2, which we'll come on to this afternoon. But how can you say in the east-west situation you're not crossing? Oh, I'm shaping. What does that mean? Well, when I get over there, I'm going to take up a channel course. So now the crossing rules don't apply to me at all. And what would happen in this situation, Manor, where a vessel is coming west-east? The pilot says, I'm sorry, the pilot engine, the motor of the pilot launch has broken down. You'll have to go across. Come round to port and come down again. Is that a vicinity situation where you say, well, she's still shaping. She's going across, right across the channel, west-east. She's going to turn to port, come down, and then shape up to be on the starboard side. Is that a shaping? In our submission, there's absolutely no logic in any of these situations. What Lord Clark was talking about as shaping was what the Yao Hai was doing. She was at 13.5 knots. She made slight corrections to port and starboard to get herself on, knowing where she needed to be when she entered the mouth of the channel. That's shaping to enter a channel course. That's entering. And the two are as different as chalk and cheese, both west-east and east-west. So that's all I wanted to say about the Kulamesin. I'm conscious I've trespassed.
Might be a convenient moment, Mr. Rainey.
It might, my lord.
I've had a rather disrupted morning, I'm afraid, but we leave it now. Shall we resume at 2 o'clock? Would that be convenient?
Thank you, my lord. Yes, certainly with me.
Excellent. Thank you all very much. We'll resume at 2 o'clock then.